Hello and welcome to the Minimum Competence episode for Wednesday, November 19th, 2025. I'm your host for today, Andrew Leahy, an assistant professor of law at Drexel Klein School of Law. On today's episode, Comey's bid to dismiss charges, Cravath's big bonuses, Selig's crypto hearing, and Trump's failed defamation suit against CNN. Let's remember, those who deny freedom to others deserve it not for themselves. And read today's legal news. On this day in legal history, November 19th, 1863, President Abraham Lincoln delivered the Gettysburg Address at the dedication of the Soldiers' National Cemetery in Gettysburg, Pennsylvania, months after the blood-soaked Civil War battle that left over 50,000 dead or wounded. The speech nearly didn't make it. Lincoln's draft was reportedly misplaced during the train ride to Gettysburg, and he completed the final version just the night before the ceremony. The headliner that day was Everett, a famed orator who delivered a 2-hour address rich in historical detail and classical references. Lincoln followed with a 2-minute speech of just 271 words. Drawing inspiration from Pericles' funeral oration in ancient Athens, Lincoln sought to elevate the sacrifices of Union soldiers into a reaffirmation of democratic ideals. He framed the war as a test of whether a nation, conceived in liberty and dedicated to the proposition that all men are created equal, could endure. In his address, Lincoln humbly suggested that the world will little note nor long remember what we say here, asserting that the deeds of the fallen, not the words, would be remembered by future generations. Afterward, Lincoln reportedly told his bodyguard, "That speech won't scour," using a Midwestern farming phrase to express doubt about its impact. But Everett, recognizing its brilliance, wrote to Lincoln the next day to say that the president had accomplished in 2 minutes what he had failed to do in 2 hours. Indeed, Everett himself is now most famous for his connection to Lincoln's words that day. Though met with mixed reviews at the time, the speech has since eclipsed the Battle of Gettysburg itself in cultural memory and certainly legal significance. Lincoln's words at Gettysburg echoed something he had written 5 years earlier after his defeat in the 1858 Illinois Senate race to Stephen Douglas. Reflecting on what seemed like the end of his political career, Lincoln wrote, "And though I now sink out of view and shall be forgotten, I believe I have made some marks which will tell for the cause of civil liberty long after I am gone." These words, penned just 2 years before he would become president, speak to Lincoln's deep conviction that principles, not personal success, leave the most enduring legacy. The Gettysburg Address ultimately became one of those marks, still telling for the cause of civil liberty over 160 years later. The Gettysburg Address endures not just as a piece of oratory, but as a touchstone of American constitutional values, echoing through the 14th Amendment and generations of civil rights jurisprudence. A federal judge in Virginia will hear arguments from former FBI Director James Comey's legal team seeking dismissal of criminal charges against him, alleging the case was politically motivated by President Donald Trump's long-standing animosity. Comey's lawyers argued the prosecution is a form of vindictive retaliation for his public criticism of Trump, who has often called for Comey's prosecution since firing him in 2017. Comey, charged in September with making false statements and obstructing a congressional investigation, has pleaded not guilty and is pursuing multiple avenues to have the case thrown out before trial. The hearing will also examine the controversial role of Lindsay Halligan, a former Trump personal lawyer with no prosecutorial background, appointed as interim U.S. attorney overseeing the case. A separate judge is reviewing whether Halligan's appointment was even lawful, while a magistrate judge recently flagged serious procedural concerns with how she handled the grand jury that indicted Comey. Prosecutors maintain that Trump's public statements and criticism of Comey do not meet the legal threshold for vindictive prosecution claims and argue the charges are legitimate. Comey's case is part of a broader pattern, with other Trump critics, including New York Attorney General Letitia James and former National Security Advisor John Bolton, also facing charges following Trump's call for retribution. Legal observers are closely watching whether courts will allow such prosecutions to proceed, given the appearance of political targeting. Cravath, Swain & Moore has kicked off the 2025 year-end bonus season for major U.S. law firms by announcing associate bonuses of up to $140,000. According to an internal memo, standard year-end bonuses will range from $15,000 for first-year associates on a prorated basis to $115,000 for the most senior associates. Additionally, the firm will issue special bonuses between $6,000 and $25,000, aligning with bonus levels previously set by competitor Milbank. Cravath, long viewed as a market setter in associate compensation, made the announcement on Tuesday, prompting at least one other major firm, Paul Hastings, to follow suit with matching payouts. These bonuses mirror those issued last year, maintaining pressure on peer firms to remain competitive in compensation. Currently, associates at top U.S. firms earn base salaries ranging from $225,000 to $435,000, depending on seniority. Firms often wait for Cravath to act before making their own compensation decisions. The announcement comes amid strong financial performance across the legal sector, where they surge in client demand, especially for transactional work, reported in the third quarter. Analysts suggest this demand positions firms for a profitable close to 2025. The U.S. Senate is set to question Michael Selig, President Donald Trump's nominee to lead the Commodities Futures Trading Commission, or CFTC, with a focus on his views on cryptocurrency regulation and election betting markets. Selig, currently the chief counsel for the SEC's crypto task force and an advisor to Republican SEC Chair Paul Atkins, has been an outspoken supporter of pro-crypto policies. In a recent social media post, he pledged to help make the U.S. the crypto capital of the world. Whatever that means. Trump's administration has embraced the crypto sector, rolling back enforcement efforts and enacting a regulatory framework for stablecoins. The CFTC could gain expanded oversight powers under the proposed Clarity Act, which passed the House in July and is now being reviewed by the Senate. That legislation aims to clarify when a digital asset is a commodity versus a security, a long-standing jurisdictional issue between the CFTC and the SEC. Selig's nomination follows the withdrawal of Trump's earlier pick, Brian Quintenz, who alleged his nomination was derailed by pressure from major crypto donors. Senators are expected to press Selig on his approach to interagency cooperation, how he would regulate crypto spot markets, and how the CFTC might handle politically sensitive areas like election betting. Currently, only one commissioner remains on the CFTC, Republican Carolyn Pham, who is serving as acting chair and has signaled plans to step down once a new leader is confirmed. The U.S. Court of Appeals for the 11th Circuit ruled on Tuesday that Donald Trump cannot revive his defamation lawsuit against CNN over its use of the term big lie to describe his false claims about the 2020 presidential election. Trump filed suit in 2022, arguing that the phrase linked him to Nazi propaganda and unfairly compared him to Adolf Hitler. However, both the district court and the appeals court found that CNN's language constituted protected opinion, not provable falsehoods. The court emphasized that Trump failed to demonstrate that CNN's statements were factually false, which is a necessary element of a defamation claim. While Trump asserted that big lie was unambiguous and defamatory, the panel disagreed, finding the term inherently subjective and open to interpretation, particularly in political contexts. They noted that if politically charged terms like fascist are ambiguous, then big lie, which is facially apolitical, must be considered at least as ambiguous. Trump has also tried to compare CNN's interpretation of his actions to his own self-assessment, in which he saw himself as exercising constitutional rights. But the court held that differing views on Trump's conduct are subjective and not subject to clear proof. The district court's refusal to reconsider or allow Trump to amend the complaint was upheld as he failed to present new evidence or show any legal error. The opinion was issued per curiam by judges Adalberto Jordan, Kevin Newsom, and Elizabeth Branch. And with that, as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more, then Minimum Competence links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow. And until then, remember, nearly everyone can stand adversity. But if you want to test a person's character, give them power.